Hello, my name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today with labor attorney Jung Bong-soo, we will cover advisory case regarding the trial employment and probationary employment, the difference between the two employment type. So, and there was a special case regarding this. So, could you explain the background and the terminology first about this employment, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I received a special the inquiry regarding some their labor disputes. So, they basically asked for whether the male employee harassed the female employee in the workplace. So then a company, because of a request of this female employee, they investigated the harassing employee, also the victim employee, and also they got some investigation result from the witnesses. So finally they make their own ceremony. Then they want to discipline this harassing employee. So they ask me for some legal opinion about this case. So then I checked about this workplace harassment case. So when I reviewed the case, so the severity of violation was not so severe, but they want to terminate this employee. So I asked the company to submit the employment contract, also the company's rules of employment. So I reviewed carefully, then I found that this employee has a kind of trial employment contract rather than probationary period in the employment contract. So what is the difference between trial employment contract and probationary employment period? So I think probationary employee, we call those two contracts, any employee who working under those contracts is called the probationary employee. However, according to the employee who are working under trial employment contract, we call it fixed term employee. Fixed term contract employee, that means company they give some certain period of employment in the beginning, for example 3 months, then they worked very well for the first 3 months, then company can decide whether to have a regular contract with this probation employee or not. So this is a kind of probation employee who are working under trial employment contract. The other one is probation employee who are working under some condition of probation period in regular employment contract. So in this case, this is not fixed term employment contract, but this employee have a certain period of time for probation period. So the employee worked very well during the probation period, then they'll go through the probation period and they'll work continuously. So it is very different. The employee under trial employment contract is called the fixed term contract. So the other one, employee who are working on the probationary period, that means they are hired regularly. However, it is conditional, when employee worked not well, and then company may decide to terminate this employee because of poor performance during the probation period. So, however, when we compare two different contracts, those employees who are work on the trial employment contract is a fixed term contract, so it's very easy to fire this employee, because the company will not renew the contract. Then the employee contract will be expired automatically. However, those employees who are work on probation period, they are hired as a regular employee, but when they are this probation employee work very poorly, in that case the company cancelled this contract. So during the dismissal during the probation period is up to the employer's judgment, as long as there is maybe some justifiable reason. So the justifiable reason is not strong for the certifying of justifiable cases. So employer may verify this employee was not qualified, then it's easy to fire this one. But so regarding this case, so this employee who are working on trial employment contract, so this employee has caused such a workplace harassment case. So in that case, I advise the company not dismiss this employee because there are only 2 weeks left for the just before the expiration of the fixed term period. So then the company already have a lot of time to investigate this his kind of workplace harassment cases. So company want to show some example to the other workers by dismissing this employee. Then I respond to them after I review their rules of employment. So according to the rules of employment, when they intend to discipline the employee, then they must give a grant opportunity for the employee. So, I mean the employee who commits some like violate company regulation. So this employee can give some written statement about his own fault or mistakes. Also, when in order to discipline this employee, company should hold disciplinary action committee, also also together with the committee members. Also, in this committee and disciplinary action meeting, the company should invite the target employee, and they must give an opportunity for this the target employee to state his own the explanation for the violation. So it may take at least 2 weeks before company hold the disciplinary action. So considering those required period of disciplinary action, is not to have such a disciplinary action. It's better to let it go. Then contract will be expired after 2 weeks. Then the company will not take any disciplinary action because contract will be expired in 2 weeks. So I advise the company, please do not take some disciplinary action process. It will cause more trouble for the company. So I think the company accepted my legal opinion for this case. Yeah.
I see. Because Korean labor law and the Labor Standard Act, according to the labor laws, it is very difficult to dismiss an employee. So I think this is why they have introduced this trial employment contract rather than 1 year or 2 year contract with a probationary period. Do you agree?
Yes, I think usually when company when they try to post some the recruitment information, usually company should be honest to post. So they hire regular employee with a probation period. So this is regular. So if they have some trial employment contract, then I think it's cheating. So company post the recruitment information for hiring regular employee, but company tried to give them okay, this is the 3 months trial period. When you pass this one, we'll hire you. I think this is a cheating. They must announce very honestly how to evaluate the probation period. So I think when company hire person based on trial period, I think they must explain about company's practice or their method to hire a new employee. So company, but in the case for hiring, hiring people based on trial employment contract, usually company cannot hire the very eligible people because they think this company hire people as temporary workers rather than regular employees. So company usually use the normal expression like they try to hire regular employee, but there will be some 3 months probation period. I think this is a way how normal job applicant accept as a normal practice. So trial employment contract is very rare, but still we regard it as a temporary employment.
Yeah, because the trial employment contract is very short, within 3 months. Even there is a workplace harassment, it's very a very short time to investigate the real status of the workplace harassment. So I think it's best that you have advised that it's best to conclude the contract at the end of the day.
So when I received the first their request in the first email, I saw there are many files attached. I thought this employee must be regular employee, but when I reviewed the employee's contract later after I requesting, then company submitted those the employment contract. So I was shocked because company, I think there is only 3 months contract contracted employee. Then company investigated with a lot of effort. So like they had a job like investigation interview with 5 people, even though this employee has only 2 weeks left. So I think a company spent a lot of time without any good result. So company, I think it can be a good lesson how company handled the case.
Thank you very much for your comment.
Okay, thank you for watching. Okay, bye bye.